Good afternoon and welcome to the Appellate Division First Department. We don't have the longest calendar today, but we're glad to see all of you here without your masks for the first time in 3 years, so that's nice too. Okay, let me call the calendar as the first two cases are going to be argued together, People versus Flores and People versus Carrera. Counsel, please stand. Counsel for the appellant. You're going to do them together, aren't you?
We're going to do them one after the other, I think, right? I mean, we'll get up together.
Okay, is there,
We'll both be arguing, in other words.
are you the same two attorneys on both of them?
I represent Mr. Carrera.
Oh, right, and you're the, okay, so you want 5 and 2 for Flores? Okay, and,
5 and 2 for Mr. Carrera as well.
okay, and who's the, okay, okay, 5, 2, 5 and 2 and 8, okay, thank you very much. L Children, which is the third and fourth cases, those are both submitted. Shelton versus Chelsea Piers. Okay, and yeah. Okay, we're going to do 6 and 2 and 6. If we have additional questions, we will, or anything crucial, we'll let you go on a little longer. Thank you, both. RCSUS versus SGM Soccer. Counsel? Okay, 7 and 2 and 5. Thank you. RCM Portfolio versus Giordano. And what about the other side? Okay, I'm going to give you 7 and 2 and 2, as you requested. Thank you. Joseph versus St. Joseph's. Either side here? Okay, so that will be submitted. Reclaim Records versus the City of New York. And respondent? Okay, I'm going to give each side 6 and 2, 6 and 2. Atlantic Specialty versus Landmark Unlimited is submitted, and Castro versus Gem Leasing is submitted. First cases for argument: People versus Flores and People versus Carrera. Good afternoon.
Good afternoon. Sean Nuttall from the Office of the Appellate Defender for Appellant Mr. Ojeda Flores. Your Honors, this is an extraordinarily troubling case. Here's what the jury heard. On Christmas Eve in 2013, as they were enjoying a beer together, my client and the co-defendant sexually assaulted the complaining witness because he cleaned the apartment on the wrong day. Even the people now concede that this story is illogical and implausible. But here's what the jury didn't hear. The jury didn't hear the answer to the DA's repeated question and summation. If this was all a lie, why would the complaining witness go through with it? And part of the answer we now know is that the complaining witness was receiving ongoing assistance and support from the DA's office, and that support was contingent on his sticking to his story. The DA never disclosed this. So both because of this serious Brady violation and because the conviction is against the weight of the evidence, we require reversal here.
Counsel, I have a question. Given that your client, as well as his co-defendant, has been involuntarily deported, Why shouldn't we dismiss the appeal from the 440 motion?
For two reasons. One is legal and one is equitable. The legal reason is that the 440 has now been consolidated with the direct appeal. This court clearly lacks jurisdiction to dismiss the direct appeal.
All right,
and
but we could decide the direct appeal, but dismiss as to the 440.
I don't think so, Your Honor. There's no support in the case law that once these appeals have been consolidated, that this court can do that, particularly when the issues are so interconnected. Here's the bigger reason, the equitable reason. The reason this case has taken so long and the reason my client has now been deported, and my co-counsel can speak to this much better as her office conducted the FOIL request and the 440 investigation, the DA's office dragged their feet, I believe for over a year, on producing the information that we had foiled and that they had suppressed in the first instance. So even setting aside the legal bar, we would ask the court not to consider dismissing the 440, which would let the DA hide behind the initial suppression and also hide behind their foot dragging. It's just not equitable. The DA's office also tries to dismiss the ongoing support that they rendered the complaining witness by saying it's just a referral or it's just counseling. That's not at all
the case
true.
with respect to the immigration status question?
I'm sorry, say again, Your
Wasn't
Honor?
it simply a referral that CVAU made concerning the immigration question?
No, one, it's not just the immigration question, and two,
Just
on
focusing on the immigration
Of
question.
course. No, Your Honor, they eventually sent a certification to, that he was being cooperative, that he had assisted with law enforcement. In fact, getting a U visa is contingent on that certification. Second, and I think this is a very important thing, it's not just the U visa. 2 days after my client's arrest, the complaining witness is already asking about crime victims' assistance. This court, incidentally, has said that just inquiring bears on a complaining witness's credibility. The office, the Crime Victims Assistance Unit, then goes and submits an application to OVS for financial compensation. That application is also contingent on the complaining witness being cooperative with law enforcement and the DA's office. So in other words, just 2 days after my client's arrest, the complaining witness is locked into his story. He has an ongoing motivation in addition to whatever, compelled him to produce this story in the first place.
But again, they certainly admitted that they referred him for counseling services, but they didn't pay for victims to receive any counseling services.
Again, it's far more than just a referral, Your Honor. They submit the application not just for counseling, but for financial compensation. And that application is contingent. We have this in our briefs. It is contingent on his ongoing cooperation.
Isn't that the
with law
U
enforcement.
visa?
No, it's not just the U visa, Your Honor. It's also the OWS. It's the financial compensation for crime victims. It's both.
And did he ever get the any financial compensation?
Two answers, Your Honor. We don't know based on this record, and two, under the case law, it doesn't matter. We don't know because on the 440, we were denied a hearing, which would have revealed that and would have revealed as well the connection, what assistance he was getting for the U visa. But under the case law, it absolutely doesn't matter. All that matters is that because of the support he was getting, he had an ongoing motivation to lie. And that supplemented this, whatever reason he had to create this fakakta story in the first place.
Okay, why don't we hear from the co-defendant? You'll each have a few moments to for rebuttal.
Thank you,
Okay,
Your
Thank you very much.
Good afternoon, Your Honors, and may it please the Court. Alexandra Mitter on behalf of Appellant Orlando Carrera. Just to briefly pick up the thread regarding the potential dismissal of the 440 and to make the record totally clear. These are claims that have to be raised in a 440. And the Court of Appeals in Harrison made it abundantly clear that that's something this Court should consider when deciding whether to exercise the discretion that it may have to dismiss a 440. And the only reason, as co-counsel said, that the 440 was raised in 2020 is because My office began FOIL litigation in January of 2019, and nothing, not a single page, was turned over until December of that year. My office subsequently filed the 440 motion, and then in October of 2020, more pages suddenly appeared.
So what caused your office to request to start the FOIL litigation in 2019 when the trial had ended in 2015?
We received the record on appeal from this court in June of 2017, Your Honor, at which point my colleague, who's no longer at my office, began investigating the case and realized that there was a potential reinvestigation to be done with respect to the assistance that the complainant was receiving at the time.
So the lag in time wasn't all on the people's side in the sense that you didn't begin investigating until 2017, it sounds like?
2017 is when we received the record on appeal from the court. So there was nothing my office or Mr. Carrera or co-defendants counsel could have done prior to that. All the while, he's sitting in prison. We're trying to get the record from the DA's office. He's sitting in prison. We're litigating the 440 motion. He's sitting in prison. We're getting permission to appeal to this court. He's sitting in prison. Not until after we're finally here on the appeal of the 440 motion is Mr. Carrera separated from his family and the country he had made, his home for the last 15 years. I would briefly like to discuss the weight of the evidence because, as co-counsel said, this case, it makes no sense. Even putting to the side—
I think you used a Latin term for Katka, I'm not sure.
I am a strong supporter
But
of—
listen, that's a jury question, isn't it? Just the evaluation of the victim's testimony. They could credit the victim.
Of course, we can always credit the victim, and respondent points out that, the testimony of one witness can be enough for a sufficient conviction, but this is not that witness.
The judge did point out that even though all of these documents were not available during the trial, but that there was very vigorous cross-examination by counsel for both defendants throughout as to some of his past history. There was some prior run-ins with the criminal justice system, which they brought out. I mean, then they went on and on. So there was a lot of questioning of his credibility during the cross-examination, notwithstanding that all these documents weren't there.
Sure, and this does wrap up back into the Brady, Your Honor, because yes, they could paint him a liar. He had lied to the police before to get himself out of trouble, and he was doing it again here.
But there was substantial cross-examination about that.
Yes, there was. And of course, the one area of cross-examination that there couldn't be as a result of the Brady violation is what was the motive in this case to lie? That's what the Brady material answers, and that was unfortunately the area that no one was able to impeach the complainant.
Requested?
Pardon?
In terms of this Brady material, what was actually requested by defense counsel?
Defense counsel requested a variety of categories of information related to the complainant's credibility. After the medical records for the complainant were turned over, like the day of voir dire, counsel realized that there were some references to a lack of payment. There was no reflection of payment and asked, who's paying? I think it would be relevant to his credibility. They noticed that there was some reference to the Bronx Family Justice Center in the medical records,
Was there actually any request for any of these records other than medical expenses?
There was a request for the Bronx Family Justice Center, which I think charitably interpreted as probably asking about the CVAU. Defense counsel didn't use the words CVAU because they had no reason to know about it. They had no reason to know about it. And respondent's position now is, oh, well, they should have, with a finer tooth comb, looked through these hundreds of pages of medical records that we gave them days before trial began and realized that, oh, yes, in fact, the therapist that was referred to in the medical records was really the CVAU, and that the CVAU wasn't just providing therapy, they were providing him with extensive benefits, including telling him that if he wanted a U visa, it required his ongoing cooperation with the prosecution. And none of that was even hinted at in the medical records. And so counsel can't be faulted for not making as specific a request as respondent seems to want from them, because the law doesn't require it. And
some of the medical records, sorry to interrupt you, counsel, happened on December 30th, like when he went to the emergency room for the first time. And there, the doctor who testified mentioned his PTSD and tied it to the rape. So in other words, he didn't have a motive to lie on December 30th, which was only days after the alleged rape.
I'm not sure that I follow the question entirely, Your Honor.
Well, in other words, that these medical records corroborate the story that the victim told?
I think
And at a time when he did not yet have a motivation because of his immigration status to lie.
I think he had a motive to lie the minute he went to the police station, which was before he went to the hospital. He went to the police station 3 days before he went to the hospital, and his motive at that point was that he was really upset that he was being kicked out of the apartment, and he was being kicked out of the apartment because he was alcoholic, addicted to pain pills, and being violent around my client's family and the other roommates. So he had a motive from the very beginning. Whether that motive subsequently changed when he realized that his complaint sort of opened the tap to all of these other benefits that he was getting from the district attorney's office is separate and apart from the motive that he had the moment he walked out of that apartment door and went to the police station. But also, just to push back a little bit, the medical records do not corroborate the complainant's account. The complainant said he had bruises all over his body, on his face, on his arms, on his hand, everywhere. The medical records note mild bruising on his extremities. And, you know, to say that corroborates the complainant's account is I think, just simply not a fair reading of the record.
Okay, thank you, counsel.
Good afternoon, Emily Aldridge for the People. While it certainly would have been better practice to turn over all of the CVAU records.
But why weren't the records turned over? I don't understand.
And my understanding is that policy going forward is that they would be. But in terms of looking at the records as they existed, they didn't technically contain Brady or Rosario information.
But
information
let's
such as...
Hold on a second, hold on. Just with respect to the U visa, isn't that conditioned on cooperation by the victim?
The record
And if that's the case, wouldn't that be something that the jury should know about?
The records regarding the U visa simply stated in full, CW is frustrated with court process, wants the case to go to trial, inquired about the U visa, expressed his feelings, provided emotional support, provided court info, provided U visa info, followed up with the client. That is the one and only mention of a U visa in all of these records pre-trial.
But that was information that was useful to him that he probably wouldn't have had otherwise, wasn't it?
But there was no express or implied promise in this. Assistance we provided amounted to information regarding a federal program.
Well, isn't that something that defense counsel could have inquired about if they'd had that information?
Under these specific circumstances in this case, this would not have amounted to impeachment for a couple key reasons. First of all, he brought this up 9 months after he initially started working with crime victims. If he was going to make
Well, no, that's the first time it appears in the records. We don't know when he first brought it up.
Correct, but since we're talking about the records that were disclosed.
Counsel, also, just taking as a premise here, you concede that the victim's credibility, quote, was the primary factor at trial. You said that in your brief. In that case, shouldn't the defense counsel have every opportunity to cross-examine the victim and show that he might have had a motive to fabricate his account?
He was subject to very extensive cross-examination, and an additional factor which shows that under the specifics...
And the judge pointed that out also in the 440, and I mentioned that, but the thing was, even though that was true, there was a lot of information they didn't have, so it may have been more extensive or more comprehensive, but it wasn't there because they didn't have that underlying information.
The information they didn't have included things like crime victims told him to live with family or go into a shelter. That is hardly housing assistance.
Well, he also didn't have defense counsel also didn't have the document, of whatever it was exactly, that the victim filled out at the police station, which wasn't turned over until midway through until his direct examination was basically over.
I'm sorry,
In the course of his direct examination, there's discussion about a document he filled out at the police station, and that was not turned over until minutes before cross-examination, at best.
Yeah, my recollection of that was that there was issues locating the document, but again, since that was not raised in the briefs, I'm unfamiliar on that particular point. But I think another very important point regarding the U visa issue is that 8 months after this crime, he then goes into inpatient psychiatric care for suicidal ideations because of the trauma caused by this incident. And then roughly 3 weeks after that is when he first mentions the U visa. And it just simply defies credulity that he would have made all of this up, put himself through inpatient psychiatric care.
The question is, shouldn't the jury have gotten the benefit of that information to make that decision for themselves after listening to argument by both sides?
Absolutely, they should. But in this particular instance, under these circumstances, it did not amount to material impeachment evidence, and there's no reasonable probability or even possibility that it would have changed the verdict, given everything else.
Isn't that kind of a difficult thing to say? I mean, as we're talking about this, given that there was just what he said and what he said, I mean, he was the only one that was there and talked about it. With all the other issues here, how can we say that there is no a possible probability or possibility that the jury might have done this? I mean, how can we really say that if these issues had been brought up as part of the cross-examination?
Because he was subject to a very scathing cross-examination, including things like his alcoholism and the prior false police report, that an undocumented sex crime victim may make an inquiry regarding a federal program should not come as a surprise to anyone. And just to clarify the record that was discussed earlier, it wasn't simply right before trial that there was mention of his involvement with the Crime Victim Assistance Unit. There was also a mention in March, so several months earlier, where the judge says, right, because crime victims have therapists. We all know that. And in discussing these, and there was no request for crime victims records at any point in time.
Well, I don't know who the "we all know that" refers to. The jury didn't know that.
This was the judge talking to
I understand the judge
attorneys.
said that, but that doesn't mean that the jury knew that he was getting assistance from essentially an extension of the DA's office as he was preparing, after he made his complaint.
But the assistance he provided, and this is also worth highlighting, the assistance he provided was not something that required him to go along with the court process. They referred him to, for example, various Bronx Works, Catholic charities.
So cooperation is not a condition of the U visa program, as your colleague suggests?
It is for the U visa, but not for crime victims assistance. So U visa, again, being a federal program, and simply giving information about a federal program that was advertised on subways, simply providing that information does not provide an express or implied promise that he is going to receive a U visa. No U visa certification was done until almost a year after the trial.
But the fact that it's advertised on the subways doesn't mean he necessarily gets the certification from the DA's office. And in order to get that, he needed to cooperate, right?
Absolutely, but I'm just saying the knowledge of the program. This was not a tacit agreement of, oh, I'm going to make this phone call on your behalf. This was simply, hey, there's this program, this federal program by operation of federal law. Here's what it is.
Right, and part of what it is that in order to get a certification from the DA's office, he had to cooperate, right?
Absolutely.
So he learned that, would have learned that, and that would have been a benefit provided to him, correct?
Absolutely, yes.
And given, frankly, the fact pattern, wouldn't it be something that the jury should have considered? As to motive, no?
We certainly can see that it would have been better practice, but under all of the facts of this case, the length of time that before he requested it, and again, the fact that he has subjected himself to inpatient hospitalization.
I'm sorry, you have a rape of the victim by two men, violent rape, and it's not clear to me even that the medical records corroborate what the victim said happened to him on the day of the incident.
There is mention of bruising on the extremities. Also, there's talk about hemorrhoids. He testified regarding hemorrhoids.
But didn't he say that he was using cream
Yes.
before this incident because he had a problem? So I don't really see how that necessarily corroborates his story.
The incident was on December 24th, and he was using cream. And then when he went to the emergency room on December 31st, they also saw the hemorrhoids. But that he was willing to take the stand and discuss hemorrhoids further goes to his credibility. And again, the fact that he had hemorrhoids, that just goes again to corroborate what he
Okay,
said.
thank you, Counsel.
Thank you.
I'll turn back to the U visa in a second, but I really would like the court to focus as well on the Office of Victim Services financial assistance. 2 days after my client's arrest, he inquires about that. This court has recognized that just inquiring goes to a complaining witness's credibility. The DA's office then submits an application for financial compensation to the Office of Victim Services on behalf of the complaining witness. I'm holding the Office of Victim Services Guide to Crime Victims' Compensation in my hand. It's cited in our brief on page 32. What other steps must I take to be eligible? Cooperate with police, the district attorney's office, and OVS. It's 2 days after my client's arrest that he's asking for this. That, too, requires him to cooperate with law enforcement, and the jury never heard this. On the U visa, I hear the people asking you just to focus on what happened pre-trial, but post-trial, they submit the certification saying that he's helpful, and they say there's no evidence in the record that there was an agreement between the DA's office and the complainant. One, the case law doesn't require an agreement for this to be Brady, and two, they don't apply for this certification after trial just because they feel like it. We needed a hearing to be able to understand what exactly was the nature of the promise, if there was one, between the DA's office and the complaining witness. And again, the jury heard none of this. I want to talk about just how material this withheld evidence was.
Counsel, would a remand for a hearing be a remedy?
We're asking that this case be dismissed, Your Honor. My client spent 8 years in prison. He deserves that, but absolutely, if the court thought that a hearing was necessary, we would welcome a hearing. The people make a lot of reference to vigorous cross-examination. I'll just use this as my last thought. Vigorous cross-examination in a close case cuts the other way. The Court of Appeals has said repeatedly that when it's a close case, when the case turns on the complaining witness's credibility, a little more doubt can turn the tide. And that's in cases involving the reasonable probability standard and the reasonable possibility standard. If I may, Your Honors, my client served 8 years in prison behind this story, which I think everybody in this courtroom sees makes very, very little sense. The jury should have heard the complainant's ongoing, incredibly powerful motivation to continue with his story. Because of that, we ask for a reversal.
Thank you.
It is cold comfort for my client and his co-defendant to hear respondents stand up and say, it would have been better practice to turn this over. It was the practice at the time. The record is quite clear that the CVAU counselor who was dealing with Mr. Carrera reached out to the trial prosecutor repeatedly, advising her specifically to review the file with respect to her Brady and Rosario obligations. So the idea that, they didn't have to do it at the time just simply isn't supported by the record. And while we would welcome hearing and another opportunity for our clients to return to this country, it's really not necessary here. I want to be very clear about what exactly the prosecution said below related to the U visa. It wasn't simply that they handed him a brochure, sent him to the Catholic Charities. They told him, quote, he must cooperate with the prosecution in order to be considered for a U visa.
Does that appear on the record?
That appears in Ms. Fragala's affidavit. It's paragraph 14 submitted with the prosecution's response. It can be there is nothing more tacit agreement than someone asking about a U visa and the prosecution telling them that they have to continue to cooperate if they want to get it. The complainant couldn't submit a U visa application if he didn't have the certification from the prosecution. And, the idea that it happened 10 months after the trial, it happened 3 months after sentencing, which is the date the case became complete. 3 months after sentencing. He couldn't have gotten the certification really much earlier than that. So the idea that there wasn't an understanding, I think, honestly doesn't require any further factual development at a hearing. And so for all the reasons my co-counsel said, and for all the reasons on our papers, we strongly urge this court to reverse the conviction and dismiss the indictment. Thank you.
Thank you. Thank you all very much. We'll take a good look at it. The next case for argument is Shelton versus Chelsea Piers.
Good afternoon, Your Honors. Barry Temkin, Mount Cotton for appellant. Thank you. Your Honors, I'm going to establish that the trial court applied the wrong legal standard below. If you look at the trial court's opinion on page 26 of the record, the trial court said there was a question of fact about several issues that were legally irrelevant. This is what the trial court said, page 26. The testimony from the various witnesses raises a question of fact as to whether Vacris had an active role at the site, whether it oversaw the work of TrevCon, and whether Vacris was at the site on a regular basis, including on the date of plaintiff's accident. Therefore, it remains unclear to the court whether Vacris had the ability to intervene and how the subject beam was being removed during the process of disassembling the grillage. Okay. Now, this court has repeatedly ruled, including in the Domenech case from 1999 that both sides cite in their briefs, this court said that in the case of an engineer that reviews plans like my client, Vacris Engineering, that it's not enough to just show negligence or it's not enough to just show that the engineering firm was present at the scene. Rather, this court requires, and the trial court should have realized, that there must be a showing of either an explicit contractual obligation, which we don't have here, or affirmative negligence. And that's what this court said in Domenech, where the court said, it is well settled.
We know what Dominic says.
Okay, sorry, Your Honor.
We hired Vacris. Chelsea says that they hired Vacris to both review and approve work by TrevCon and review and oversee work done by CEOCon. I'm probably mispronouncing it. So I gather what their theory is that there should have been more planning by Vacris to understand how the disassembly would go forward in the limited space available, and that somehow creates an issue of triable fact. That's what I understand their argument to be.
Yes, Judge Moulton, and as I understand that, if you believe that and accept every fact that's in my adversary's brief as a matter of law that doesn't rise to the level of affirmative negligence, which this court requires, and in which in the Domenech case and also the Brooks case from the Second Department, because this court requires a showing of affirmative negligence. And if you look at page 21 of my adversary's brief, of Chelsea Piers' brief, they admit that there is no evidence of affirmative negligence. On page 21, my adversary writes, quote, whether Vacris thereafter committed an affirmative act of negligence remains to be seen, as discovery has not ended in the trial court action at this time. Vacris reviewed the grillage plans and failed to comment on them as requested. Whether this constitutes an affirmative act of negligence is a question of fact for the jury to decide. And, Your Honors, I submit to you that's absolutely 100% wrong on the law, because an omission as a matter of law is not what this court means by an affirmative act of negligence.
But Counselor, sorry, go ahead.
No,
Go
go
ahead. No, no, no. Go ahead.
What about if they were negligent, though, which I think is the allegation, in the way they designed and constructed how this would initially be built, which was partially contributed to causing the accident which occurred?
Well, Your Honor, there's no evidence in the record or even a claim of design defect here.
Part of the claim is that there was not enough space to move around to remove it based on the way it was initially constructed. Why doesn't that go to the initial design, because it was designed to have the space that it did?
Because there is no evidence in the record to support that. Now, my
I thought
adversary...
wasn't there also a claim in the record that while they were in the process of removing this, this grillage, and they were trying to get rid of one of the beams, and they were having problems removing it. So wasn't that also an allegation that went to the design of that particular feature, and therefore there was a problem that may have contributed in some way to the happening of this accident?
Okay, let me address that head on, okay? Because there's two theories as to how this accident happened. There's the plaintiff's theory, and there's the theory of Chelsea Piers, okay? The plaintiff's theory...
Not unusual in a personal injury case. A few different theories.
Right. The plaintiff's theory is that a forklift struck an I-beam, that the forklift was driven by an unlicensed driver who was a fellow employee of the general contractor, Trevcon. And the plaintiff's testimony in the record is, he says, I looked at the machine, there's a quote, Tim, that's Loyster, his coworker, was sitting in the machine, and I started screaming, pick the effing beam up, pick the effing beam up. And then afterwards, his coworker, Loyster, went up to the injured plaintiff and said, I'm sorry, I'm sorry, I'm so effing sorry.
That's hearsay, though, right? We don't have any, that comes through Mr. Brado. That doesn't come through.
I think that's admissible as an admission because he's a party.
No, because it's double hearsay. It comes through Brado. In other words, if he said it to someone else.
No.
How does it come in? Tell me.
It's 347 in the record. That's the testimony of the plaintiff. The plaintiff said, quote, what I just said. So the plaintiff says that his coworker said that, and Brado also says he spoke to a Trevcon employee. He couldn't identify him by name. Brado spoke to someone, and this person, who we all know is Loyster. This other person said, quote, it's my fault, and I hit it with the forklift. But let me put it this way. That's the plaintiff's theory. Like Justice Kapnick said, sometimes you get competing theories. Okay. My point is this. There are two theories here. Neither theory involves any negligence by the engineers. Because the plaintiff's theory, which all the other witnesses, except for Loyster, agree to, is that Loyster drove a forklift into an I-beam and knocked it over. The Chelsea Piers, their theory, which they have an expert witness whose affidavit's in the record at page 2225 to 2235, their expert witness, Gordon Aker, said that this I-beam spontaneously flipped over. It just fell over due to pressure on it. And according to their expert, they say at record page 2232.
Finish up because you've gone over your time.
Let me just quote their expert. Their expert says, stored energy was the result of a poor welding technique here, and that led to the residual stress that caused the I-beam to shift. So either it's poor welding, according to Chelsea Piers' theory that they put in the record, or it's a general contractor drove the forklift into the I-beam. Either theory means it was the general contractor's fault and not the engineer's fault. All the engineer did was design. And my adversary admits in his brief, page 21, there is no evidence of active negligence. Thank you.
Okay, thank you very much. You'll have a few minutes in rebuttal.
Good afternoon, Your Honors. May it please the Court. My name is John Karpousis. I have the pleasure of representing Chelsea Piers in this matter today. And I think
Can you address the issue raised by counsel about what the affirmative negligence was of Vacris?
Right. The answer to that is there's no proof yet. See, what my adversary is trying to do is get a directed verdict here. Discovery's not over.
On summary, Well, this is a summary judgment motion. Don't you have to, lay bare your proof or else,
Well, we do, Your Honor, but a party cannot meet its burden on summary judgment just by pointing gaps in my proof, right? I haven't had an opportunity to secure an expert yet as to that particular issue. That doesn't mean that it's...
well, couldn't you have put in secured an expert to oppose this motion?
I don't think that's my necessary burden in this particular case. First of all, we haven't even decided how much of a duty and what the scope of the duty that Vacris has undertaken in this case. If Your Honors look at the record at 2928 through 2934, you'll see that it's a little bit more than just approving plans by CCON, and it's CCON, Your Honor. They commented on those plans. They had their hands all over this thing, Vacris.
Did Vacris have someone on site?
Yeah, yes.
And on the day of the incident?
There's a question of fact as to that. No one's 100% sure. He might have been there in the morning.
And what were the responsibilities of the individual from Vacris on the job site?
Vacris performed general inspections throughout the project to ensure compliance. But with respect to the design of the grillage,
But specifically with respect to safety, the safe removal of the structure.
Well, they absolutely had that obligation because they admit that in their deposition. And if you look at Mr. DiPasquale's testimony at 2773 to 2775, Your Honor, we questioned him extensively on it, and we got a lot of, well, I don't know exactly how much we did with respect to the reviewing of the grillage for safety. The fact of the matter is that they had it, they had the plans, they commented on the plans several times. It wasn't just a rubber stamp. Their input was sought, their input was given. Was their input proper? That's an important question that has to be answered, and that they won't even concede that.
What about with respect to the welding requirements? Did Vacris have any responsibilities making those
Well,
decisions?
certainly they got the plans, and the disassembly of the grillage, if they don't use, for example, if they didn't use tack welding, which they did, if they used bolt welding, maybe this accident doesn't occur. Now, I'm an attorney for 30 years, and I know that. You don't think an engineering company might have maybe made that comment? That would have been helpful here. Again, because they had these plans and exercised, they put their nose in it, to use the street parlance here. They involved themselves in this in a way that, as Justice Kahn properly found, creates a question of fact. Now, I want to turn to Domenech. I know Your Honors know what it says, but Domenech was limited to the concept of when the engineer is hired to assure compliance with construction plans and specifications. I would submit to Your Honors that Vacris did more than that here. That because they were asked to comment and did comment, and there was even language from De Pasquale that said, we won't approve it. We won't approve these plans unless these specifications are met or that specification is met. Once you start doing that type of thing as an engineer, then you don't get summary judgment. Then it goes to a jury, especially if you can't agree as to what the scope of your duty is. Thank you, Your Honors.
Okay, thank you.
I'll be brief. First of all, the other side, Chelsea Piers, did have an expert. They hired an expert. His affidavit's in the record. He does not mention the engineer. Okay, their expert is a professional engineer. There is no reason why that expert couldn't have, mentioned us. There's nothing in the record showing affirmative negligence. Yes.
So addressing that, there's an allegation here that Vacris had someone at the job site, maybe not at the time the accident occurred, and also with respect to the welding requirements. If in fact Vacris had something to do with approval of the welding requirements, and that was done negligently,
right,
which caused the grill to stick and ultimately plaintiff gets injured.
Yes.
Isn't that sufficient to go to the jury?
First of all, no, it isn't, Justice Singh, because there has to be more than an omission. There
But
has
this
to
is
be
more,
an
isn't this more than an
affirmative,
omission?
there has to be an affirmative act of negligence. In other
You
words,
have a guy on the, you have a guy on the site, their claim is that he's involved in safety. Isn't that sufficient?
first of all, if you look at the record, what counsel said isn't supported by the record. If you look at Mr. Brado's testimony at record 708, he says, quote, there's some, referring to Vacris, there are submissions that are done from the vendor to Vacris. They stamp the submission and say the bolt is correct, but they do not, Vacris, they do not go down until the work is completed, and then look at the work and say, yes, this is completed in accordance with the specs, and then I pay it.
Well,
But
Mr. Temkin, you were reading from page 26 of the record, which was Judge Kahn's decision, where you said he found a lot of issues of fact that you didn't think were that relevant. But he also, Justice Kahn that is, said that the plaintiff testified that Vacris workers had drawn up plans for work at the site. He recalls that Vacris was around when welds were being cut at the site and may have been present to take a reading on the column hourly or every 3 hours.
Right.
So it's a little bit more than just not an active participation in what was going on the date of the accident. And that is in the record. So how do we not consider that, at least to raise an issue of fact at this
well,
point?
my adversary, good question. My adversary hasn't told me what we did wrong. It's incumbent on the claimant here to say Vacris did something wrong,
But
and
the
this is
plaintiff
it.
is saying that these were, the judge read the whole record, we looked at the record, the plaintiff testified about that. I mean, he can say, well, the plaintiff said this, so that raises an issue of fact.
But no one said Vacris did anything wrong. All I'm hearing from my adversary is they were at the scene. They're at the scene of the accident. They looked at plans. But let me address.
Just finish that, finish
Let me
up,
address
okay?
the safety issue, because this is what Mr. Brado said, because it contradicts what my adversary said. It's question, record 790. Was it your understanding that it was Vacris's responsibility to review the shop drawing for the means and methods of how the shoring was actually being constructed? Like what tools they were using, what welds they were using? Answer, Chelsea Pierce, no. That specific means of methods of how it was designed and how it was put together, I did not pay Vacris for. Okay, so, and as far as safety, my client testified we had no responsibilities for safety at all. I just want to address the discovery issue.
Just
Discovery, okay?
15 seconds, that's it.
Chelsea cross-moved for discovery, and there have been 12 depositions in the case, and Chelsea hasn't come to this court and said, you know, we just need one more deposition of such and such a witness to prove the act of, they're not saying that. Discovery is closed below, and they have not come up with any reason why the 12 depositions they've taken and the expert they hired is insufficient to create a fact dispute. And mere negligence in the air is not enough. They have to show
Thank you, counsel.
affirmative.
Thank you. Thank you both. RCSUS versus SGM.
If it pleases the court, Joseph Zemanowitz of Stone Zemanowitz, and we represent the defendant's appellants. The court should have granted summary judgment because there are no damages here. In fact, I heard, Justice Kaplan, your comment in the prior case where, with respect to summary judgment, you lay bare your proof. There was,
Well, I mean, the thing was, the judge did indicate that there were certainly questions on the damages, but that would have to be proven at trial. She didn't necessarily find that there's absolutely no damages, but they're going to have to prove them at trial.
well, there were absolutely no damages here that were ever shown. Back in 2015, when this case started before Justice Owing for preliminary injunction, there were no damages that were shown. Through thousands of documents that we produced, there were no damages that were shown. We're dealing with the leader of the industry, self-proclaimed leader of this electronic industry, and he testified, I don't know of any damages. The court itself said the damages theory that the plaintiff presented was, quote, woefully inadequate.
Well, but of course, since a lot of this a lot of this case has to do with the adverse inference that the court granted, part of the reason they may not have been able to prove the damages as definitively as they would have liked to was they didn't have the evidence they would have had if there hadn't been a destruction of the WhatsApp conversations that went back and forth. So it's kind of both connected. And I think the judge indicated that if there is going to be an adverse inference, then they'll be able to at least put forth damages. Will they win or not? I can't tell you.
But let me address that directly, Your Honor, because the judge said that there were three principal reasons why she issued an adverse inference in this case. One of them was that the defendants were tardy in addressing the problem. That, we don't even know where in the record the judge received or obtained that information. The case started with a preliminary injunction. After a few days, this upstart defendant who enters into the industry from being a teacher in a school comes in, starts a business with an assistant, knows nothing, quickly grabs on to what it is. It is a nanosecond type of industry. Thousands of people, members of the industry compete for every single transaction. All information is exchanged. He said it, the adversary said it, and our unrebutted expert in the industry said it.
That's not what the adversary is saying. Isn't the adversary arguing that there is confidential information about how they do their pricing, and that is what was disclosed in those destroyed WhatsApp conversations? So it's not just the identity of the customers, but it's at what price they were selling the goods.
But that is the mistake that was made, because in this industry, all pricing lists, and we've put it in into the affidavits and even showed...
Obviously, everyone's not selling it at the same exact price.
This material is available. This is how you get, if you click on, you get that transaction immediately. And it has to work with a nanosecond. Everyone knows what's available.
Well, that's right, that's your position, but obviously the other side is taking a different position and has articulated a different position and is certainly arguing that they have confidential information which was disclosed by their sales representative in violation of the confidentiality agreement. You're disagreeing, but I don't know why that doesn't just raise an issue of fact versus that your version is correct.
We're not only disagreeing with that, we're disagreeing because the source of the information and everything that possibly, and we argue about it and we disagree, but could have been transferred or given over to our client, they had. That phone with the WhatsApp messages, they had from their own employee's phone. All of those messages. They've never said they didn't. In fact, in the record, their own attorney
They're not saying they didn't have
admitted it.
all the messages. They're saying they had some of the messages for some period of time, but not all of the messages, and that your client deleted the ones that they didn't have.
They're not saying that they don't have all the messages that were done. They're saying that my client's phone did not have all the messages. They had all the messages from Mr. Strauss's phone. It's the same communications. No one claimed that Mr. Strauss didn't have. They took away his phone. They confiscated it immediately before anything happened, before my client knew what was going on. They confiscated his phone. They had all the messages. They went for preliminary injunction. Then we started with discovery. Immediately, it was found out with this WhatsApp situation. And let's talk about what happened with the WhatsApp situation. No one at that time could have ever realized that the WhatsApp was something that was not like email that could be transferred over automatically to the next phone. You trade a phone, you get a new phone, all your information and
Isn't that the
data
whole
is
benefit of WhatsApp,
gone.
that the messages don't get retained by WhatsApp? That's why people use WhatsApp.
Excuse me?
That's why people use WhatsApp. That's
Now
that's the whole
everyone knows
basis
that.
of the app.
And no one knew that at the time. They never disputed that. No one. That's why Justice Owing did not take any measures against what happened. It was understandable. But more so, when they have thousands of documents, they had every single sale my client made. They have that. And can they match that as to what they could possibly have sold that? They didn't have one. Not one page, not one document in 7 years. They have nothing. And their CEO said they have nothing, not because they couldn't get the information from my client's phone. They had the information from their own employee's phone. They had everything they needed, and it's all in the record.
Okay, let's hear from your adversary, and you'll have a few moments to respond. Thank you.
Good afternoon, Your Honors. Jonathan Cooper for the plaintiff respondent. I want to start with noting that it's hard to imagine any instance where spoliation sanctions would be...
Counsel, address what your adversary said, that through Strauss's phone you had all the same messages, that there were no gaps.
That is absolutely untrue. Page 376 of the record, paragraph 34 of the complaint, Judge Singh, it is very clear that when they retrieved Mr. Strauss's phone immediately prior to commencing litigation, this was all they were able to retrieve, and we produced that in full in the record. There's about 100 pages in the record, which is the sum total, which is a series of chats between October and November 2014. Those are the only chats that were recovered from Mr. Strauss's phone. And in terms of the additional gaps, that's also noted at pages 886 to 889 of the record, which comes from their phone, and it shows on its face significant gaps that were outlined in the letters from May of 2015 to, I believe it was Justice Owing at that time. Simply put, there is no substitute at all for those 8 months worth of missing WhatsApp chats. As we detailed in our brief, we highlighted several of those chats which detail how Mr. Strauss was giving the SGM defendants live pricing information, actively competing against his own employer by feeding these leads to the SGM
So what
defendants.
about Mr. Zalmanovitz said that, oh, the pricing information is something you should just click on and find? Is that?
Absolutely untrue, and there's no basis for that in the record, Your Honor. And he was unfairly using his inside information as to RCS's pricing, and this is, again, detailed in our briefs, to say, hey, you can actually undercut my own employer to make these deals. And there's just no universe, as I indicated in the record in the oral argument before Justice Maisley, there's no universe where that's okay, where you're working for your employer, actively working to undercut them at the same time in exchange for a payment that you're getting from this competitor.
So let me ask one other question. Mr. Zalmanovitz started by talking about the problem with damages, which Judge Maisley recognized had been a problem, and I explained why it seemed there might be some justification with the adverse inference. But even with that, is your client going to be able to show that, in fact, that your client was dealing with these same clients, that the plaintiff was dealing with the same clients, so that they actually undermined them or took away some of your business, so that you really did suffer any damages? Are you going to be able to show that?
With difficulty, I believe we can. And that's actually outlined in Mr. Feit's affidavit, which is in the record, because his damages computation are saying these are the deals that we did with these same exact customers at that same time with the identical products, and this was our typical profit margin.
So we probably would have been the one they were dealing with if Mr. Strauss had not given the information to our competitor.
Correct.
How about the unjust enrichment claim? What are the damages there?
The unjust enrichment, again, that goes to the spoliation issue, and it would be theoretically duplicative of the same thing from the unfair competition.
Just answer my question. What are the damages? What damages are you claiming with respect to unjust enrichment?
It was simply another cause of action trying to get to the same relief of damages, Your Honor.
So you're seeking lost profits in the unjust enrichment claim?
It's the same type of lost profits that we're seeking. It's the same.
Can you get lost profits for unjust enrichment?
I believe so,
Is
Your
there a
Honor.
case law that supports
I
that?
believe that was part of the E.J. Brooks case, and also this case, this court's opinion, I think in the U.S., something to be Shearer, if I remember that correctly. Okay. If the panel has no further questions for me, I will rest. Thank you, Your Honors.
Thank you.
Thank you. I'll be very brief. We have the industry expert Mr. Lieberman, who put in an affidavit that is unrebutted, that all of this information was exchanged by thousands
So in other words, in this industry, everyone knows what the rates are?
Exactly. And the reason why my client was successful later on is because his terms that he offered were better, not pricing. His terms were you could pay in 30 days.
So what's your
never did that.
explanation for why there were all these exchanges going back and forth between their employee and your principal of your company?
Well, we've
And
established.
payments going back and forth?
We've established those
Just by
exchanges.
chance?
Because, no, there's exchanges with everyone. Everyone who's on this exchange, on these exchanges, exchange information. They admitted that they even exchange information with my client. They go to an exchange and they talk about this one or that one. How's that credit risk? How's this one? How have you done business with that one? All of that is the same. The question is, do you have inventory available? Do you have terms that would be more satisfactory to them? That's the kind of industry, and that's what Justice Oing recognized right away, and we wrote a quote from his opinion in our brief. Your Honor, if I just may add one more thing, which is that recently this court and Justices Kern and Moulton were on the panel. It was Domingo v. 541 Operating Corp., 210 AD 3rd 423. And it says some things very interesting with respect to spoliation. Number one, that you have to show that the sole means of establishing your claims is what was taken away from you. That is not true here at all, where thousands of documents, bills, invoices, all of those records were provided to them. They have their own records, which they didn't produce. All you have to do is match them up. But there is not one single sale that they lost. Secondly, the court said that even in that case where there was no explanation provided why documents weren't preserved, which is contrary to what we did, we explained the situation that we had. Nevertheless, the court said that it falls short of establishing what is necessary, which is, quote, culpable state of mind on the record. You cannot say that there was any culpable state of mind on the record for our client to have given his assistant his phone and then inadvertently things
But that
were overwritten.
coincides with Mr. Greenwald admitting that he extended loans to Mr. Strauss, loans, quote unquote, to Mr. Strauss, right?
That's correct.
So those two things together, you know, create an issue of fact, it seems to me.
They created an issue of fact as to spoliation, which is why the court should not have ruled that there was gross negligence here.
Okay, well, thank you both very much. We'll
Thank
certainly
you.
take another look at these papers. The next case for oral argument is CMG Portfolio versus Giordano. Good afternoon.
Good afternoon, Your Honors. Brian Grafman, Bora Goldstein for defendant appellant James Giordano. This case concerns a $24 million purchase of legal and medical receivables back in 2012. Plaintiff had an unlimited due diligence period and after 6 months signed the agreement. Only after the sale did plaintiff hire an industry consultant who knew legal receivables and found instantly from Cambridge, the seller's own servicing records, cases he deemed as impaired, most clearly labeled by Cambridge as ineligible.
Counsel, wouldn't that, ultimately you're arguing is that plaintiff didn't take reasonable steps to protect itself against deception, but doesn't that just merely raise an issue of fact?
Well, there's no question of fact here that everything was disclosed, and I have it, you can see it right before with your own eyes in the record, as I point out at page 12 of my brief, page second volume, 1234 in the record. I took 2 emails of plaintiff's own representative to Cambridge, where he has the spreadsheets. And the spreadsheets have at the column that says funding status. Remember, there were funding cases, and this was at that time, it was the prior lender to Cambridge that was the lender, and we'll get to that in a moment. But it says under funding status, they're coming to take over as the funder, ineligible 133 times, 15% of the
Wasn't
portfolio.
it sort of unclear in the record as to what anybody's understanding of what that list meant, ineligible?
Okay, so plaintiff concedes that the word ineligible comes from the prior lender, which was Partner Ray. And those lenders, as I said, they were in place at that time. What the lenders cared about was not whether a case was open or closed, that's something else they raised. What they cared about was, is the case eligible to support the credit that we are providing? Because we have certain parameters, and you can see the underlying prior lender agreement at page NICEF 258. It's not in the appendix, but it's there, and it talks about eligible cases right from page 1 right throughout, eligible cases.
What about, I don't mean to interrupt you, but I'll probably forget this if I don't. There was one particular doctor who seemed to have an awful lot of what turned out ultimately to be fraudulent medical claims as part of the record, that he didn't actually do the services or didn't do all of the services that he was billing for. Dr. Katzman,
Correct.
might have gotten wrong. And that there was no, and the part of plaintiff's claim was that the defendant should have indicated, even though they didn't know the extent of his fraud, the fact that there were some problems with his records, and that that your client misrepresented the status of those records.
Right. Okay, two things about that. First, the Katzman receivables are not even in the schedule where they make representations about the quality of the receivables. And that's at page 25 of my...
Maybe they should have been.
Right, but it was a throw-in to the purchase. They said, we're going to give you this also. It's at page 25 of my reply brief where I talk about the record. But in any event, what they say is Katzman he eventually had some problems with overbilling down in Florida, and they claim that our client somehow were prescient about this fraud. They have no proof of it. Their own lawyer who took over, the lawyer who was down in Florida that our clients were using, later became their lawyers. It's all in the brief. And he doesn't come say he knew. In fact, we have emails of him after the purchase saying, here's the status. He doesn't say anything about some fraud. Now, there was an arbitration case that I will give you. And in the testimony at the deposition, he said all he did was he told us about Giordano, told us about the case. Now they're starting to say that it's something else that I don't understand what else it could be, but that's what they're claiming now. So if you find there's a factual issue in that, well, that's something that might be isolated, but it seems clear from his deposition testimony. He said Giordano he didn't say that he owed a couple of $1,000s in legal fees on it. And I don't know, it's a $24 million purchase, a couple $100, $1,000, not really material. But, and that's something that Cambridge reserved anyway, but that's in the brief there. But going back to the ineligible, in the companion servicing agreement, because Cambridge was to service the portfolio, everybody agrees, and they agree they agree that the protocols and procedures that were to go on with the servicing after the sale were the same as when prior. So they knew what happened prior, and they spoke with partner rates in my brief at page 10 when they did their supposed due diligence. Now, I just want to say also, this is not like they have to rummage through boxes. It's all electronic. You want a report, you get a report.
So let's just, counsel, can you address the issue with respect to open cases? There's a claim here that there were cases that were improperly labeled as open when, according to your own company policy, they should have been written off, something like that. Would that have thwarted their efforts to do a full due diligence?
Now, yes, Justice Singh, thank you for that. Again, as I said, this is an ongoing business that was servicing cases. They don't immediately close a case if something goes bad. Why? Our expert, unrebutted, as one of my counsel before said, unrebutted says there are various reasons why a closed case could still collect on. For instance, You ever have a malpractice case?
But no, but the claim is that you weren't following your own company policy. What you said your company policy was, allegedly, was uncollectible receivables were to be written off per company policy, but in this instance, they weren't being. Doesn't that raise an issue of fact?
Well, hold on. In the agreement, there's nothing about open cases. All the agreement says is.
We're talking about due diligence. We're talking about, your claim is that they should have done better due diligence. So again, with respect to their ability to due diligence, not about the agreements.
What they're pointing to show a case was not a good case is our records, the servicing records that they had available, and they didn't hire an expert, a consultant. Later they did, and the consultant found it instantly, and I show on the second day he's there, the third day, the fourth, next day. And the other thing is, maybe that's a contract claim at best. How is that fraud? They had everything available to them. They don't point to, and by the way, our own page 1938 in the record, our own collections person says, I've collected on cases that were lost. As I just mentioned, our expert says all kinds of cases, like a malpractice case, new defendants, reopening a case. Look at the Jean Carroll case. That's a little out there more, but that was a dead case that came back alive. But that's, okay. And
Okay, counsel, let's hear from your adversary, and you'll have a few more minutes to speak to us on rebuttal. Thank you very much.
Good afternoon, Your Honors. May it please the Court. James Riley of Oved Noved LLP on behalf of Plaintiff Respondent RCM CMG Portfolio Holdings, which I'll refer to as RCM. I'll be brief. I think the 4,500-page record on this one claim sort of speaks for itself and demonstrates that plaintiff's fraud claim is permeated with material questions of fact that require a trial.
Counsel, you make a great deal about that you did more due diligence than even was required in your brief. But since many of the Excel files had the term outstanding ineligible, which you contend is meaningless, wasn't it part of the due diligence to find out exactly what defendants thought that term meant?
So there's a few things with that, Justice Moulton. So the whole idea that this term outstanding ineligible, I think my adversary in his brief says something like it jumps off the page. So I think the first thing that's important to understand is the spreadsheets where this term outstanding ineligible appear are massive, massive Excel spreadsheets with many tabs or sheets in each file, probably dozens of sheets, hundreds of columns, thousands of rows, and in some of these Excel files, but not all of these Excel files, the term outstanding ineligible appears. So there are certain sheets that are labeled open cases. And when you click on that open case, which suggests that these are all a list of open cases, there are certain cases within that spreadsheet that say outstanding ineligible. Now, their testimony from Mr. Giordano's own company, Cambridge, another defendant, several of those people testified they had no idea what outstanding ineligible meant.
Yeah, I'm just saying about due diligence, though. I mean, because the term's out there, why not find out what it means to the defendants, since you're buying these assets from, or these receivables from the defendants?
So what it meant, we did later find out what it meant. What it meant was, and I think my adversary touched on this, what it meant was prior to the sale of the portfolio, there was a lender that worked with Cambridge, and pursuant to that lender's own terms and conditions of the loan, there were certain requirements for the receivables to be included in the borrowing base. Those requirements included, the length of time that the case had been pending, other things like that. It had absolutely nothing to do, and I think my adversary even said this during his argument, it had absolutely nothing to do with whether the case was still pending, meaning that the receivable could still make a return, or whether the case had been lost years ago. It's a completely separate metric that...
But if you're buying this portfolio for millions of dollars, doesn't it behoove you in doing your due diligence to check out what this meant, not afterwards get an expert to review those? Otherwise, you know, maybe you shouldn't have bought it, I don't know, but it just seems that you have an obligation to review what is available for you to review. If you said these were not at all available, you could not in any way have found these, that would be one thing. But if you could have looked at these documents and you could have, you know, asked questions about them, shouldn't you have done that before you buy this portfolio?
So, Your Honor, my response to that is the DDJ management case, which we cite in our brief, stands for it's a Court of Appeals case. It stands for the proposition that you don't need to go to the ends of the earth. You don't need to read every single piece of paper of, you know, a company that you're acquiring or a portfolio that you're acquiring. To satisfy justifiable reliance, you need to do what is reasonable. And as we laid out in our brief, we have done what was reasonable here, and that's backed up by our expert report, which says, look, the gold standard in these types of transactions, in this type of industry, is to have the audited financials, which we had. We had backup of the audited, what we thought was the audited financials. It later turned out that it didn't actually comply with GAAP, and there was an issue with Cambridge's accounting firm. But what we thought at that time was the audited financials, the backup to the audited financials, and most importantly for this claim, the representations of Cambridge's owner and CEO, Mr. Giordano.
Okay, anyone have more questions? Okay, thank you very much.
Thank you very
Counsel.
much.
Very briefly, first of all, we just mentioned the representations of James Giordano, and just real quickly, I mentioned this in my brief at the opening brief, page 34 through 36. They say he said it was viable and collectible. Well, here's $24 million. Thank you. The point is that's not in the agreement. It's not in the complaint. It wasn't even in their EBTs when they asked, what did he say to you? It came 8 years later in their post-trial motions, post-discovery motions, where they said, as we stated in our depositions, and then state things that they didn't state in their depositions, he said it was viable and collectible. Well, even if we give them that, you know, that's not something you could reasonably rely on in a $24 million purchase like this. They also say he said it was written off. Same thing. Not in the agreements, not in the complaint, wasn't in the deposition, only in the post-trial. They did say they were handed a policy. They don't say who handed them, what it was, where it was. They don't identify it. But some policy that said it was written off, they don't identify it anywhere.
Well, look, I mean, in Judge Schechter's decision, she didn't find that there absolutely was fraud. She said that there are issues of fact. How are there not, based on listening to both of you, not some issues of fact here on both sides?
Well, because here there is no question that everything was available, because their consultant came immediately and said, where's the servicing notes? They admit that they watched Cambridge's people on the servicing system calling the attorneys saying, what's the status of the case? They never ask. If you look at my reply brief, and they say, did you ever ask? No. If they had you asked, would they give you yes? They asked, we didn't know they never saw the servicing notes.
But again, as your adversary points out, it's reasonable due diligence, not, you know, scorched earth due diligence. So doesn't that raise an issue of fact?
It's not reasonable if you don't hire an expert. They never did this. These are different. These are cases. These aren't, they thought they were buying bars of soap. How do you do a historical analysis on a case? And I just want to say one last thing on DDJ, sorry.
Yes.
The court says, page 153, the rule defendants rely on was stated more than a century ago, ... This rule has been frequently applied in recent years where plaintiff is a sophisticated business, person, or entity that claims to have been taken in. In some of these cases, the rule serves to rid the courts of cases in which reasonable reliance, that's like this case, is hypercritical. And one last sentence, the rule rejects claims of plaintiffs who have been so lax in protecting themselves they cannot fairly ask for the law's protection. And that, I submit, is this case.
Thank you. Thank you both very much. And our last case for oral argument is Reclaim Records versus City of New York.
Good afternoon. David Rankin, R-A-N-K-I-N, from Beldock Levine Hoffman for Reclaim the Records. We're here today because for two reasons. One, there are two reasons to grant attorney's fees for Reclaim the Records in this action. First, they substantially prevailed below. It's undisputed that the court opinion below said that the records needed to be produced, and they said that for two reasons. One, they said it was res judicata. As you look for the briefs, everybody agrees it's not res judicata. We posit that it's actually collateral estoppel. I don't think there's anyone that seriously has an issue with that.
So to the question with respect to substantially prevailing, the records are now available publicly to everyone. So how did you substantially prevail?
Well, for two reasons, Your Honor. First of all, the records that we requested are not publicly available. One, we requested the high-definition photograph.
High-def records aren't on the system anymore?
No, there are records of the Old Town records on Doris, if I just refer to it as Doris, Doris's system. However, if you look at the joint appendix at 120 and also at page 53, it shows that the records, they are in possession of different records, right? They are not, the records that are on the website are not the actual highest definition records that they have, and that's what we requested.
But there are high-definition records available online to everybody, aren't there?
There are, but here's something that I think is very important about this.
So in what sense, to follow up on what Justice Singh asked, how did you prevail if they were already available to everybody online?
Well, I mean, because of the court's ruling on it below. But here's the issue.
Well, I understand
the issue with the records that we requested. See, Doris sells the actual high-definition records, the highest definition records they have from the microfilm, right? They sell them for $45 an image. We posit that that is not allowable under the Freedom of Information law as...
Wait, I'm sorry, because the highest definition records aren't available because they're medium def or low def? That's a violation of the law?
Yes. We requested a specific record. That's the high definition record.
That's not, well, I'm not sure that's accurate. Didn't you just request initially just the low def, and if possible, high def?
If possible.
That's my recollection. Maybe I'm wrong.
There is a phrase in there that does have a caveat on it. I think a fair reading of it, and I'm not disputing Your Honor's reading of that, I think a fair reading of it is, look, we want the high definition records of it, and obviously as the correspondence progressed, the actual request was further clarified.
So you think, so you don't think that they can charge $45 for that?
No. I think the FOIL is very clear about how public records are to be distributed. And it's...
You're not contending that all public records have to be distributed for free under FOIL, are you?
No, absolutely not at all.
But I'm sorry, one more thing, just adding on to that. There are medium def records on the system, correct?
Correct.
So your complaint just is that the highest, the best quality records aren't on the system?
Correct.
And what's your authority that they have to provide the highest, best, most beautiful records that there are? What decision says that?
Well, I mean, there isn't one. Obviously, I would have cited that front and center in the brief.
Where is that argument coming from, that they have to produce the highest definition?
The issue is, what is a record, right? We requested the scans of the microfilm, which were already ordered, produced to us. And
they did send you all the records. They sent them by Dropbox and mailed some. They sent you the records.
Very low definition records with watermarks on them such that they weren't
sent
used.
the records.
They were altered records. I mean, they created a second document that didn't actually have the records on it that were requested. And you can find,
Because they weren't high definition? Is that your argument? They didn't produce the records because they didn't produce the highest definition records?
I mean,
There's no dispute they produced the records.
we do not dispute that documents were produced. The documents which were produced did not convey the information, and that's the key distinction.
These records were, some of them were over 350 years old, am I right?
Correct.
So how good a definition, I mean, I was trying to look in the record, at least at some of them. I really wasn't sure which ones exactly I was looking at, but I mean, what's the difference whether there's a faint watermark or not? You can't do the work that you're doing with these records, given that they're over 350 years old?
Well, this is exactly the issue, because most of them are handwritten. If it were a situation where it was a typeface or something like that, you would have a pretty good idea of what the situation is. I mean, obviously they have typefaces at the time, but most of these are handwritten records, which is why the detail of it and the watermarks is so important. So they produced altered records, which they created a record, which of course is.
What are you saying altered? I'm confused by that. Are you saying that they intentionally altered it?
Well, there are two records I think that are at issue, and let's just be clear of what I'm referring to when I say altered records. They physically produced records to us. The records they produced to us were very low definition and had watermarks on them, okay? I am positing to your honors that that is an altered record because it is one, not the high definition records that they had. They had to do some sort of process to reduce the record itself.
You think they purposely made them lesser records to send them to you?
Yes, and they put a watermark on them. Like, that's what happened. The second record, which I think is at issue, is the record which is online. And the record online, I think, is a fair read of it is more of a medium quality record, and not the actual high definition records which were produced, which were requested.
Okay, let's hear from your adversary, and you'll have a few minutes in rebuttal. Thank you.
Good afternoon, Your Honors. Tahir Sadria appearing on behalf of the City of New York and the Department of Records and Information Services.
Go ahead.
What is your response to their argument that the records you produced were altered?
The records, I mean, the records that were produced were, I mean, they weren't, they were watermarked with the identification of Doris, but I mean, they weren't altered to produce, I mean, the petitioners mentioned themselves that when you, like, even just going onto the website, you know, you can bring up different, you know, different versions of the definition of it in order to save space.
I'm sorry, did the archivists in any way change the records?
They didn't, no. I mean, the only way that they changed the records is they did, in terms of the documents that were produced, is that they had the watermark on the images, if that is the question.
Why would you put the watermark on the images?
It's just well, it's like in the rules of the Doris in terms of producing the archival materials, the standard like documents that are produced for free, they have the watermark just identifying them as coming from Doris. But I would just like to say, there's 2 points I would like to get to. First, the records that were requested were the records exactly as they appear on the website. Those are the high definition records. They're not medium definition records. They're the high definition records that were requested. And if you look at the initial request and every comment on it up until petitioner's reply brief, they are asking for the records as they appear on Doris's website. And the practice of hosting records on a website, especially proactively, not in response to a particular request, but just posting government records online as a matter of course is also, it's a more common process now, and it is something that the Commission on Open Records has described as a win-win situation, process that effectively exceeds the requirements of FOIL, because it makes the records available to a greater number of people more easily, and thus promotes.
I'm confused. On the website,
Yes.
what are the records high def, medium def, or low def?
The records that are on the website are high definition.
And if I wanted a record, I have to pay $40, $45?
So if you want a copy of the record as it appears on the website, you can go to the website and you can right-click on it and you can save it and you can download it and you can
You have to pay for it?
that you do not have to pay for. No.
So what do you
You
pay
can
for?
also, you can separately, you can ask Doris for, go through their process and obtain a high definition digital file, separate digital file, the way that they had requested a digital file, or you can request a glossy print, and those things cost, they're, according to, there's a schedule of fees, but there's fees that are charged.
But anybody can go online and get a copy.
But they can go online
of
and
the
get a
high
copy.
definition just by clicking
Yes.
on the Doris website.
Yes, they can.
And your argument is that satisfies FOIL.
That satisfies FOIL. With the city's position is that this is a process that ought to be encouraged, and that this is, I mean, and it is the most common way of responding to FOIL requests now is by posting documents online. And I mean, certainly it is not a denial of disclosure. We've made disclosure available to the widest number of people possible. If the court has no further questions, I will rest.
Okay.
Yep.
Yes, certainly. You have 2 minutes on rebuttal, or on your cross-claim, or whatever you want to talk about.
Well, I think we've gotten to the issue here, right? There are 3 sets of records. There are the records that were physically provided to my client, which were the low-definition records. There are medium-definition records, which you can admittedly and freely talked about.
So the
records.
quibble between the two of you is whether those are medium or high def, right?
Well,
and so you want us to go on the website to figure out whether it's medium or high def?
No.
Isn't it sufficient? Isn't it sufficient that a historian can go on the website, right-click, download the document, use the document as he or she sees fit, and if they want something special, they would pay for it, you know, a glossy print or whatever.
Well, see, I think this is a very important distinction. It is absolutely permissible to pay for the printing process if the city government wants to put a frame on something or the presentation. What's not permissible is to have a government record that is being charged for outside of the FOIL law. FOIL has...
They just said they don't charge for it. That's the point, that the records that are available online are not being charged for.
She said you could download the high-definition ones and right-click on it.
My apologies for interrupting. That's the issue. We were given low definition. Online is medium definition. There are high-definition records which you have to pay for. And they don't dispute...
That's not what counsel said. Counsel said that what's online are high-definition records which you can download as high definition if you choose to. And I assume that depends in part on the high definition of the computer receiving it as well as what you're getting.
That's just the file density. And if you look at the joint appendix at page 120 and also at 53, it indicates that there are the high definition records, which is what they're charging for, right? If it were actually the thing that they were charging for is something you could just right click, they wouldn't be charging for it. Right? There's a third set of records.
They could be charging it because it's an easier way to access the records.
Because they don't want to spend, I mean, because it takes their time to right-click them all and make them all available and send them to you and get them to you, so maybe they're charging for that.
But it's providing a different record. I see my time is done, but I do think this is important. It's an actual different record. The thing that they are charging for is the high-definition record, and that's what we requested. That's what was ordered to be produced.
If possible. Well, I did
Thank you.
look at it.
If there's any more questions.
Okay, well, let's hear, you have 2 minutes also. Thank you, counsel.
Okay, the request that was made was for copies of the documents exactly as they appeared on the website. So they're the same records. And the city's position is also that a request for a record is a request for information, and that FOIL is about information. It is not about providing the highest definition display quality prints.
So what's the distinction in terms of what you pay for and what you get versus what I would download by right-clicking?
So it's really, I mean, to a large extent, I mean, it's a matter of convenience. If you go to the website and you go and you right-click and you zoom in and then you print and then you save as, you get a high-definition print.
With a watermark?
No.
Okay.
You can also make a request to Doris for a copy of a digital file or for a copy of a glossy print, and they will charge you for that. And I'm sorry, but the city's position is that even if, city's position is two things. One, the documents that are available online are high definition, and they are precisely the documents that were requested in the requests, which made specific reference to the quality as they appeared online. But even if they were a somewhat lesser quality, the FOIL would not require that we produce the most high definition in order to comply with FOIL, as long as the documents are legible and the information is conveyed. And it is permissible for Doris to charge for this archival material, for high definition copies of this archival material.
Okay. Thank you.
Thank you very much, Your Honor.